I knew people didn't like paying taxes, especially property taxes, but I didn't know people would be so responsive to our deep dive into property taxes in Prop 19 in California. There were certainly some spirited comments aimed at a certain political party. I'm attorney Andrew Bethel, and if you haven't watched my in-depth video all about property taxes, Props 13 and 19, and transfers between parents and children, then feel free to pause this video and go watch that one first, because today I'll be responding to a handful of good questions that were raised as a result of that video. Be sure to hit the like button, subscribe, and ring the bell. Share the video with someone who owns property in California, and let's get into taxes. Stopped watching in first couple of minutes when he mentioned the average property tax rate, which is a meaningless number. Well, lack of punctuation aside, thanks for commenting. Since property tax rates are all over the place due to how they're calculated, partial reassessments, and Props 13 and 19, it's difficult to use anything other than an average or median, and I only found averages when looking. For our first real question, let's talk ADUs or accessory dwelling units. These are a separate complete home for one or more people located on the same property as a primary residence. ADUs are also known as granny flats, in-law units, backyard cottages, secondary units, casitas, laneway houses, and DADUs, which just mean a detached accessory dwelling unit. With the way property values have been trending in California and the lack of viable housing supply, ADUs have become increasingly popular in the state to either bring in a little extra rental income or allow for children to move in and help mom and dad, or vice versa. This brings us to our first question. What if an adult child lives in an ADU on a transferred property and has for many years prior to inheriting the full property? Does it matter if they live in the ADU or the primary house? The basic answer is that we ignore the ADU in that the county assessor is looking at whether the child is living on the property or not. They can live in a room inside the house, the garage, a barn, an ADU, whatever, so long as they live on the property, the parcel of land that's on the deed. Then the physical location as to where they live doesn't matter. However, this answer changes if we're talking multifamily housing such as a do, tri, or quadplex. In that case, we still don't care where the child physically resides, but the property is going to be partially reassessed because it's not a single-family home, or more precisely, it's now considered as multiple single-family dwellings. Thus, a half reassessment on a duplex, a 2/3 reassessment on a triplex, and a 3/4 reassessment on a quadplex, and so on. Our next question is on a topic I've already lectured you about, adding your kids to the title of your home and joint tenancy. I'll link to another broader video where I discuss this topic in great detail in the corner as well as in the comments below. This commenter said, "My grown child lives with me and has been disabled since childhood. He can't afford a huge tax increase. What about joint tenant? That's what my mom did for me." All right, let's take this step by step. If that child lives with you, then no reassessment upon the transfer, whether it be adding them to title now as a joint tenant or passing it on as an inheritance. However, I would strongly caution you not to simply add the adult child to the title as a joint tenant. Firstly, you mentioned they're disabled. In what capacity? Physically or mentally or developmentally? If it's not a physical disability, then you or they may run into a capacity issue where we have someone on title to a house who doesn't have the capacity to do something with the property. For example, selling it. Next, it would be in the child's best interest to inherit the property so as to benefit from a stepped-up tax basis, which would minimize or avoid capital gains taxes when they sell the property after your death. If you add them the title now, then you transfer over your tax basis and no step-up upon the whole of the property at your death. Going further, something I didn't notice when I first answered this question a while back, the commenter mentions they received the property through joint tenancy after being added to title by their mother. When this commenter's mother added her to the title, their tax basis was transferred to the commenter. Thus, if the commenter were to sell the property now, then only half the property's basis stepped up to the date of death value. The remaining half, the half given to the commenter, is still operating at their mother's tax basis, likely the initial purchase price. Thus, with this commenter's mother likely saved in legal fees by not creating a trust, they will likely now lose many times over if the commenter sells the property during their lifetime. Also, I feel bad for the accountant who will have to figure all this out when tax times come, especially if the commenter now adds their child to title. Aside from my video on adding your children to the title of your house and why you shouldn't do it, I also have a great video on how to minimize inheritance, estate, and capital gains taxes that I recommend you watch after this one for more information on avoiding capital gains and preserving a stepped-up tax basis. Lastly, Keep in mind, joint tenancy is a temporary probate avoidance plan and only works as to the title owners. No contingency planning when one of the owners dies. Thus, a trust is more robust, avoids probate, and can be changed at any point in time. At the very least, in a case like this, I recommend at least to do a revocable transfer on death deed. I did a video all on revocable transfer on death deeds back in 2022, which I'll link to above, so you can watch that for more. Be sure you're subscribed though, as an updated video on those transfer on death deeds is in the works. Next, how about transfer from sibling to sibling? This one is nice and easy because it's, well, simple. Nope. Sibling-to-sibling transfers are always reassessed no matter what and always have been. Propositions 13 and 19 have no bearing here. As a side note, I did do a video a while back discussing a case where a son received a property from his parents' trust, but the county considered it a sibling-to-sibling transfer because of how the transfer was done. How about veterans? How about our military folks who are 100% disabled? They're not supposed to pay property taxes by California law. If you are a disabled veteran compensated 100% by the Department of Veterans Affairs, then you can skip out on property taxes. This benefit also carries on to your widowed spouse so long as they don't remarry. However, that benefit ends there. If there's a transfer of the property from you, then we look to normal Prop 13 and 19 rules. Finally, I want to have a short discussion on the potential silver lining of California's laws on property taxes, since there were a lot of opinions on the matter in the comments. The one on screen now is just an example of some of the sentiments I saw. Unfortunately, this is a double-edged sword. On one hand, yes, your property taxes went up 2% per year every year. On the other hand, your property value likely rose by at least double or triple that each year, every year, on average. While yes, you cannot necessarily do anything with that appreciation without either selling the property or borrowing against it, but your asset's value, the property value, is increasing faster than the government can even tax you on it. All of this, in my opinion, encourages people to hold on to property for as long as possible, disincentivizes development in the area, as in more housing, and thus you have the recipe for the situation California is in. Too many people trying to live here, yet not enough housing stock, forcing the price of housing to increase as more dollars are chasing fewer products, thus incentivizing holding property, and so on until you have a situation where the state is offering what is essentially a lien on your house to borrow the down payment to buy a house, where you're going to also be borrowing to finance the rest of the purchase. And this program runs out of money within hours of opening because people are just that desperate to buy a house. Anyway, rant over. California's property tax laws are so important because they hit so many pain points that tick people off. The price of housing, incentivizing holding property rather than selling, sudden tax spikes based on what feels like arbitrary rules, and, well, arbitrary rules. But let me know in the comments below. What do you think? Clear as mud, or was I able to help your understanding of property taxes in California? Think we should get rid of all these rules and just tax based on property values each year, or should we just get rid of property taxes altogether? Remember to like, subscribe, and share the video with another California homeowner. I'm attorney Andrew Bethel, and I'm here to help you make sense of the law in your estate. And I'll see you at our next meeting.